through our program, Arbitrating Patent Disputes, Setting the Right Course from Clauses Through Discovery. Let me start with a little bit of...
Excuse me, there is a tremendous amount of background noise. Whoever's rattling or typing should stop.
Can people click on their audio button to mute unless they need to speak?
Right, so that's just what I was getting to. There are a number of people scheduled for this call, maybe even 30 people or something. So everyone should have a mute button on their screen. If you could take a moment and find it. And we would appreciate it if you would mute your audio when you're not speaking. To get it a little more organized in terms of taking questions and in terms of getting your thoughts and soliciting your thoughts so we can get rid of the background noise. If you have a question at any point, please go ahead and type in the chat box, which you'll find in the lower right of your screen. And we can see that, and to the extent we're able to get to your questions, we'll do that. The second thing is you'll see that there are points during this presentation which we'd like to be at least somewhat interactive as we could, when I'll solicit thoughts from the audience, or Jarkko will. And when we do that, you'll want to unmute yourself, but when we get to you. But before that, if you could just type something in the chat box, whatever it is, your name will then pop up and we'll be able to call on you. We will unmute some of the phones if we can do that, but we'll be sure to unmute whoever's trying to talk when that happens. So hopefully that'll work. You'll be muted until you put something in the chat box, and it can be anything, unless you are not connected by phone, in which case you'll have to type out your answer in the chat box, I think. Anyway, this is we're new with this program.
Where do you find the mute button?
That's a good question.
This is Rosemary Talley. Just hit the little microphone button in the upper right corner. It's green when you're speaking, and then if you click it, it should turn to red. If you're online.
Thank you.
Okay, yeah, there you go. All right, I hope everyone understands that. Well, we're experimenting with that aspect of things, but let's get started. Thank you all for coming. This is a program sponsored by the Tech Coordinating Committee of our organization, SVAMC, and I'm delighted that there's as much interest in this program as there is. Let's first take a look at our presenters. Okay, if you could hit the mute. Okay, thank you. Let's begin by introducing our presenters. Jarkko, if you'd introduce yourself, I would appreciate that, a little bit about you and your practice, and I'll talk about me, and then we'll get into this.
Sure, happy to do so. Thank you, Dave, for inviting me to partner with you on this webinar. My background is that I've been active as an arbitrator and a mediator since the mid-'80s, and I've been doing it full-time since 2000 after a 27-year career as a litigation partner with a San Francisco law firm. I've got an office in hip and up-and-coming and soon-to-be overly congested Oakland with two other full-time neutrals, Randy Wolf and Bill Quimby. And although I'm not a patent expert, I've had the opportunity to arbitrate and mediate many technology disputes, including several that did involve patent issues.
Okay, and I'm David Allgaier. I practice out of Lindquist and Venom in Minneapolis. I've been a commercial litigator and intellectual property litigator since the early 80s. I've been arbitrating and mediating commercial and intellectual property cases for about 15 or 16 years. I've done quite a few patent cases within my arbitration practice, which led me to start a blog on that topic, which later led me to turn that into a book, which just was published by the ABA and sort of forms the basis of our talk here today. We're being a little less ambitious than I have in other talks in that I think to deal with this topic very fully, we've split it into two parts. So we're really going to be talking about everything that happens up to the hearing in the patent arbitration process. And hopefully that will give us enough time to do some of these things in a little more depth than they sometimes are allowed. And also, as I mentioned, you'll see there are times when we'd like to get input from you. I find normally from these things, I think I tend to learn more than I teach, simply because with a group like this, there's a lot of wisdom out there that we'll be tapping into. Okay, with that, let me just talk a little bit how patent arbitration arises in patent disputes. Oh, let me start one other thing. My book is really directed towards folks that are perhaps patent litigators or in-house patent counsel or people who deal with patent issues but may not be familiar with arbitration. Obviously, in this audience, I have a lot of people who are familiar with both. So this talk may seem aimed at more towards litigators and practitioners, but certainly your ideas and thoughts on this will be solicited and helpful. And maybe you can straighten me out on a few things as we go along here. Well, the way that arbitration arises, of course, in patent disputes is there's almost always a written contract. And if there is not, there is unlikely to be any patent arbitration. I guess there have been cases where there's agreements post-dispute where people would agree to arbitrate things, but in my experience, it's awfully unlikely in patent disputes in particular, but probably disputes in general. If one side wants to arbitrate, the other side probably doesn't once it's come to a dispute of that sort. So let's take a little look at the kind of disputes that are common in patent arbitration. One type is ownership and misappropriation claims. If there are employment agreements and it involves anything having to do with inventions, an employee might claim to be an inventor, and that may end up in an arbitration. There's a sort of famous case out of Minnesota. It's actually more a trade secrets case, but Seagate Technology versus Western Digital. There was an employment agreement, and it mostly was, as I said, about trade secrets, but it's kind of famous because the arbitrator, a former judge, actually sanctioned one side for fabrication of evidence by the employee, also found out the employer's lawyers, or at least he decided the employer's lawyers knew about it as well, which led to an award of over $600 million. So these issues can get pretty serious in some circumstances. Another pattern you might see is a shareholder who's forced out, but then goes ahead and uses patents and inventions. If they happen to have an arbitration clause in the shareholder agreement, you're going to have those kinds of disputes in arbitration. And many employment agreements, of course, have assignments of inventions and so forth. Those would be ripe for patent issues entering into arbitration. Confidentiality agreements with arbitration clauses might have some patent related issues. And I know I've had supply agreements that are within them have joint development agreements, and at times those lead to patent disputes. So there's a lot of ways they can get there, but probably the most common dispute comes out of license agreements. Many license agreements provide for arbitration. And because we know from the Lear versus Atkins case that, and I'll talk about the statute too, that often opens up the issues in a patent arbitration to validity and enforceability and all sorts of other things because of the law that can apply to that. So you can have as many issues really in a license agreement, it would seem, as you can have in a standard patent case, and they can get certainly pretty deep into that. Okay, let's talk a little bit, Jarkko, maybe you can talk about the considerations that go into whether arbitrating a patent dispute as opposed to put it in the courts or some other way of handling it?
Well, I guess that given that a good part of our audience is involved with the Silicon Valley Arbitration and Mediation Center, I'm going to be preaching to the choir here to those of you who are pretty familiar with arbitration. But an obvious advantage of arbitration is to be able to choose who your decider will be, someone other than a recently appointed judge who has been a prosecutor all his career, his or her career, or a jury of a tabula rasa jury. On the other hand, some parties to a contract may want to have a tabula rasa. So, but that is one advantage, is having control over who the decider will be, and then you can look for someone to be appointed who has familiarity with the technology that's involved, or even perhaps specific patent experience. In my experience, I have found that what works pretty well, if you're going to have a panel of arbitrators, is to have perhaps two experts, and then one who would serve as chair, who has familiarity with the process and can manage the process and focus on that, even though they may not be steeped in the technology or in the interstices of patent law. Another issue that comes up in arbitration versus litigation is whether you have a right to an injunction. The AAA arbitration rules provide in Rule 38, the commercial rules, that an arbitrator can be appointed as an emergency arbitrator to hear the equivalent of a TRO or a preliminary injunction. I just finished a week from the time being appointed to my ruling on such a case, involving actually some patent issues as well. Depending on the jurisdiction, some jurisdictions will only provide that you can go to court to get an injunction rather than pursuing it under the arbitration rules. If the urgency of the dispute is so intense that you need to, get a hearing on in 2 days or something like that, it's unlikely that even the Arbitration Association would be able to appoint someone in that short a period of time to hear it. I would recommend that those of you who are in the business of drafting arbitration agreements to consider putting a provision in there, as I've seen in some cases, that specifically authorizes the party to seek an injunction in court without waiving their right to arbitration. Moving to discovery, it's typically more limited. I think those of us who adhere to the American Arbitration Association admonition that we should be more muscular as arbitrators will focus on trying to manage the process in a way so that discovery doesn't get out of hand. But there are arbitration agreements that I've seen here in California where the parties incorporate CCP 1283.05, and in doing so, they basically buy into the full civil discovery process. And so that can kind of frustrate the advantage that arbitration can provide in terms of more limited discovery. In terms of summary judgment, it used to be the case early in my career that most arbitrators would not be comfortable considering a dispositive motion in the context of arbitration. But lately, the trend has been in the other direction, and particularly aided by provisions in arbitration rules such as the American Arbitration Commercial Rules that specifically contemplate the possibility of a dispositive motion, provided that the parties can convince the arbitrator or the panel that it is likely to either narrow the issues or resolve the dispute. In terms of whether arbitration is faster, I think it is. In my experience, even in complex cases, the typical timeline is 6 months to a year to the time of hearing. And so it sort of beats going to court and trailing in the courthouse hallway waiting for your trial date. And I think as Dave has put in the outline, it can be less expensive. It really depends on, the muscularity of the panel in terms of how they manage the process, trying to keep the costs down. Some of that, of course, is in the hands of the parties. But it can be less expensive. And there is finality. I'm not going to talk about the ways in which an arbitration award can be vacated, but the grounds are rather limited. And you can provide for not judicial appeal, but for an appellate arbitral panel to review the award. And then in terms of privacy, and there'll be more about that later in the program, but it's private in the sense that there are no court reporters, no courtroom reporters that will run to the newspaper present in the hearing, but it's not confidential unless the parties specifically agree to make it so in their agreement.
Yeah, I think that's
now
true.
Turning.
One thing I would say is that one advantage is, while it's not, it isn't necessarily confidential. Of course, the arbitrators keep it confidential. What we do know is that not everybody with a computer and a Pacer account is going to see all the filings in the case. It's not going to happen. So that is an advantage right there. But as you mentioned, actually there can be more of an advantage.
Okay, shall we turn to the next page? Arbitration disadvantages. Yes, arbitration, can be more expensive in a way because you're paying for the arbitrators and there's an administrative fee, especially, when you have a panel of 3 arbitrators. But you have to think of it in terms of being offset by limitations on discovery that can certainly run up fees in a case, assuming you have a, quote, muscular arbitrator or arbitration panel. And there are no appeals, so you eliminate that expense in most cases. We've talked about discovery. It can be limited. That some may see that as a disadvantage. Third-party discovery can be complicated. I know that in California, unless you specifically refer to CCP 1283.05, you're not going to be able to take discovery depositions under the code. Also, there are various rules in various jurisdictions that limit the subpoena reach of an arbitral panel. Having said that, in my experience, I find that parties are always asking me to issue subpoenas. I give the other side, a 24 or 48-hour opportunity to object if they think it's improper. Most of the time, there's no objection. And I have no idea what happens to that subpoena, even though it may not be authorized. And I suspect that most third parties that are faced with such a subpoena don't have a problem producing documents that are called for. On the other hand, I think if someone asks for a third-party deposition, that's probably going to be a little different and more contested. We've talked about injunctions. In terms of pre-hearing motions, I find that there are fewer motions, although dispositive motions are becoming more popular. In terms of handling discovery disputes, most arbitrators that I know will have an expedited process provided for hearing any discovery issues. There's a perception that arbitrators are baby splitters, and that's a huge topic that's been addressed in various articles and studies. But in my experience, just speaking for myself, I call them as I see them, and I try to apply the law to the facts. And I reject any notion that I'm there to make a compromise award. I think where compromises are perceived by participants is in terms of the remedy that's awarded. And arbitrators do have a wide discretion in terms of the remedy that they are authorized to award. And then limited grounds for appeal, those are listed. I'm sure almost everyone in the audience knows those narrow grounds. I'm not going to go into those in detail, but there is no appeal, but you can provide for a special appellate panel under the American Arbitration rules, and I think under the CPR rules as well, and under the JAMS rules. But in my experience, that device is not frequently used, and it certainly adds to the expense. And I frankly have not heard of a reviewing appellate arbitral panel ever overturning an award.
I haven't seen a lot of use made of it, but the way I think about it, if you've got someone who's opposing an arbitration clause in your agreement because they're just uncomfortable not having appellate review, and that can be really true in patent cases because we know that as to Markman decisions and such, at least historically, the Federal Circuit used to overturn those with some frequency. Some people might just be more comfortable with an appeal. It might be a way to get arbitration into the agreement if your opponent is worried about that. Okay, let's talk about another issue that I've heard about a lot lately, and that is why not just rely on the patent office to deal with your patent disputes? If you tie yourself into an arbitration, aren't you foregoing the ability to use this very new popular procedure, relatively new popular procedure of inter-parties review? With the American Invention Act and the changes to the patent law, a whole system has been set up for review of sort of an administrative trial within the patent office of the validity of patents that are asserted, and some large percentage of them seem to be getting overturned. I think that pendulum's going to swing fairly soon. But there are advantages that someone challenging a patent has. So this would be a licensee typically who might not want to give this up. The burden of proof is lower in the patent office. It's clear and convincing evidence in court to invalidate a patent. It's only a preponderance of evidence to do this at the patent office. And the patent office makes the broadest reasonable interpretation of the claims. That makes more prior art relative because you're a bigger target. And makes more prior art relevant, and that has been an advantage that many people seem to like through that procedure. And it is quicker and less expensive than litigation. I don't think it's particularly quick or particularly inexpensive, but compared to patent litigation, is a lot more so. So why would anyone not want to just rely on that? Well, the problem is it doesn't really solve what may well be most of the issues when you have a question of in a license agreement. What about infringement? The patent office does not decide infringement. They never do. And in many cases, the patent issues are there, but other issues may be part of the party's dispute as well. I've certainly had cases where it drags in trade secrets, breach of confidentiality agreements, all kinds of other things within the agreement when the parties are having a commercial dispute that involves patents. And it's still a fairly long process, and it really all has to happen before anybody looks at the issues in the case other than validity of the underlying patents. And it is kind of rare, by the way, to have every claim of every patent invalidated. So you probably would narrow things down, but you probably won't, through that process, necessarily solve the whole thing. It's very public in the patent office. That's a public organization. It's a government organization. Everybody can look what's happening. And there may be other reasons not to do that. Now, for some people, it may be that a licensee may be so enamored of the whole inter-parties review process or other post-grant reviews that they might want to make sure in their arbitration agreement that they're able to do that. But if they are, recognize that if you do that, you're probably adding another year, a year and a half to actually getting your situation resolved.
Davis Yarko, I have a question. Is any discovery permitted in inter partes review? And what about the precedential effect? In arbitration, some arbitration awards are granted some collateral estoppel effect, assuming the process is robust enough.
Yeah, there is discovery allowed. It's probably more limited. There are even some depositions allowed, but the courts, they're really sort of administrative law judges that take care of all this. My understanding is that they limit discovery a little bit more, although there can be some depositions and testimony in some of those things. So there's a certain amount of that, but it's really, in my understanding, turned more into an administrative process. It's not the kind of robust presentation you get in court, which can be either good or bad, but it's much more technically focused. And in terms of res judicata effect, yeah, if the patent office decides the patent's invalid, it's invalid forever and against everyone. Okay, so let's look at how to encourage use of arbitration in patent disputes. And I think we all have, those of us at least who have seen that arbitration can be a good way to resolve patent disputes, particularly in the right type. The thought is, how do you get folks to do this and embrace this, given that without an arbitration clause, it's very unlikely that you're going to see patent arbitration of a patent dispute. It's not going to happen. And one thing is, be on the lookout for the right types of contracts where it makes sense to have these. Licenses are an obvious one, but employee agreements, applied agreements, and development agreements all are sensible things where you might want your patent dispute to be private and to be decided pretty quickly. There are negative perceptions out there of arbitration. I can't tell you how many people have said to me, even people in my own firm. In fact, we've had debates about it at forums in the firm. Why not arbitration? Almost everyone has an arbitration horror story they can tell. Usually they lost the case, but they didn't like the way that it went. Another thing that happens is the rules and procedure and education by arbitration organizations are happening all the time, which hopefully will get the word out on the benefits of arbitration in these. I mean, I've had cases as an advocate where without an arbitration clause in the patent license agreement, the case just was not, my client would start up in that particular case. There wasn't going to be a case. They would not have been able to vindicate their rights. They just couldn't afford it. But in arbitration, they were able to do that. Now, that's maybe not good news for some of the licensors in the world, but in this case, with startups and others, it's really something to consider. Okay, let me open it up to the group a little. So if you have got something to say, type something in your message and we'll make sure to unmute you. From the group, who has any ideas about ways to encourage use of patent arbitration and get clauses into license agreements and other contracts? And what can we do, maybe as a group, to encourage that? Any thoughts?
Can I jump in there? It's Philip in Sydney.
Sure.
So my experience is based, I guess, on some 20 years of litigating for a generic pharmaceutical manufacturer and doing a lot of freedom to operate challenges. It's a fairly, I guess, niche scenario, but it involves a couple of factors which may have application more broadly, and they're these: that first of all, of course, you've got the territorial limitation of a patent, but in the pharmaceutical context, you have a global product. And so there's one attraction in having a single arbitration to deal with a dispute globally instead of having to run infringement or revocation actions in multiple jurisdictions. That's the first point. And associated with that is the fact that you often have very specialized expert witnesses, and you don't want to burn them, so to speak. So when they've been cross-examined in one jurisdiction, then you kind of already know what they're going to say in the next jurisdiction. And you don't have enough supply of fresh experts in some of these arcane areas of chemistry. So that's the second thing. The third thing for the so-called ethicals, I say that advisedly, is that sometimes they feel a little bit vulnerable about their patent. And they would rather have an arbitration with a generic so that the arbitrator, of course, cannot invalidate their patent globally. So all the arbitrator can do is, in a sense, decline to enforce it in that particular case. And that gives them a comfort level where they have a soft spot or an Achilles heel in their claims. They end up with a $1 license to the generic. And everyone's happy and they get to keep their patent. And of course, the generic's very happy because the patent's keeping out their competitors. So there's a couple of situations there where arbitration really is very well adapted to delivering a result that the global litigation or the logistics really can't match.
Yeah, all good points. Thank you very much. That's very helpful. Mr. Doherty mentioned you had a comment, I think.
I'm good, thank you.
Oh, okay, thank you. All right. There is a question here whether we've had experience with the, let's see, oh, we kind of moved on. Okay. With appellate arbitration. I actually have to say I haven't had a lot of experience with that. I know it exists and it makes a certain amount of sense, but not something that most people seem to have embraced, at least yet. All right. Let me talk a little bit about patent arbitration in the law, in the law in the United States, that is. As it turns out, the federal law specifically provides for patent arbitration. And the reason this was passed is there was a time when a number of courts said, we just think it's against public policy to allow arbitration of patent disputes. Patents are sort of imbued with the public interest. They provide a right to exclude, and we just don't think that we should have those sorts of things decided privately. Federal law said, you know, we don't agree. The Congress didn't agree, and they passed 35 U.S.C. Section 294. But it actually has some things that are interesting. It says you can arbitrate a patent dispute, but the arbitrator must consider any defenses of invalidity, non-infringement, failure to comply with Section 112, and other conditions of patentability. So that is fair ground in your patent arbitration. The statute requires it. Interestingly enough, the award binds the parties but doesn't bind anyone else, although it certainly could be important, particularly because there has to be, for the award to be enforceable, notice of it has to be given to the director of the PTO. So that has some implications for privacy because the award ends up at the PTO to be enforced. There's also 35 U.S.C. 135 for derivation proceedings, which asks the question, is the first to file the true inventor? And it has the same requirement of notice to the director, and only the parties are bound by that as well, which makes sense because that's the patent office's ultimate responsibility to decide who the right inventor is. So there are implications for privacy that arise out of that. But I would suggest it's not the most difficult breach of confidentiality that people will face. After all, to get an award enforced in court, normally you have to file it or make reference to it in some way for the court to deal with it. So you're never going to have total privacy in many cases anyway. And then there's an interesting issue of whether the parties could simply abide by the ruling, whenever it was, foreclosing a public filing at the PTO. So you wouldn't have to go to court Whether that could be considered inequitable conduct not to follow the statute after an arbitration, I have no idea, but it's something I would think through before I decided that.
It's Philip here. Can I just quickly jump in on that point?
This is Yarko. I want to. I'll let Philip go first. Go ahead.
I was just going to say, in some of mine, that's been a specific consideration, and the way around that is to, because you're running an international arbitration, you can choose which patent to use as your proxy, as it were. And oftentimes, because of this very issue, which is only a US issue, you choose a foreign patent. So you might choose the UK patent or the Australian patent as the one to actually litigate, and everyone agrees to be bound by the outcome. But technically, you have not had a ruling on the US patent, and therefore you avoid the notification requirement.
Yeah. Okay. Right. Good point. Helpful in an international setting. Yarko,
I did. I have not encountered this issue in my practice, but I'm getting an echo for some reason. Anyway, in looking at the statute, 35 USC 294E says the award shall be unenforceable. If parties collaborate and decide to disregard that provision, I'm wondering if, a year later, one party might not say this is an illegal contract and is unenforceable, notwithstanding. So I think there may be a way to paper around that, or perhaps enter into a separate settlement agreement that somehow parallels the arbitration award. But I think it's a thorny issue, at least to my mind.
Yeah, and I would think that you'd want to think that through pretty carefully. Okay, let's talk a little bit about drafting arbitration clauses. Now, again, with a lot of our audience being arbitrators instead of people drafting the clauses, this may not be quite as important to you. However, it seems to me that one of the important things to do is get the word out on how to do these clauses correctly. And let me cut to the chase here and basically say the one thing you ought not to do, or people drafting these really ought not to do, is take the last clause someone in the office used and just use it. And in this particular example, you'll see there are references both to the Federal Arbitration Act and the Minnesota Revised Uniform Arbitration Act, some notion that there's going to be mediation before there's an arbitration, questions of picking an arbitrator, throwing in attorney's fees. And I won't go over this in great detail, but in all of these circumstances, you have some inconsistent provisions. You don't really know what rules apply because they don't have an arbitral organization. And I know that people just sort of have a knee-jerk reaction to throw in fee shifting, but that can cause some real problems. So
yeah, some of the other bad drafting. I'm sorry.
Yeah, go ahead.
I was just going to chime in and say that some of the ways in which arbitration clause drafting can create problems is overly stringent time limits that run the risk of the arbitrator losing jurisdiction if they don't meet a certain unreasonable deadline, or overly narrow criteria for the selection of the arbitrator that make it impossible for the administering body to find someone that fits those criteria. And, we can talk at length about party-appointed arbitrators, but I would discourage, well, first of all, under the AAA rules, a party-appointed arbitrator is presumed to be neutral, even though they've been appointed by a party. But some arbitration provisions provide for effectively partisan arbitrators, which is, from my point of view, not a desirable process because it adds to the expense. And provisions that specifically state that the arbitrators must apply the applicable law, while that may be laudable, it can create another basis for vacatur of a decision based on manifest disregard of the law.
Right. So those can all backfire, even though people are trying to make the process perhaps as favorable to their side as they can have the exact opposite effect. Another one I see is people who don't have administration of their arbitration. They decide they'll save the fees of administration. I think that's a real mistake in most cases, and this is an example of that. I'm going to suggest, and I'll let Jarkko chime in on this, how he feels about it, but I'm kind of a minimalist when it comes to arbitration clauses. I would start with going to the standard clause that the arbitration provider is. ADR has a standard clause, they all do, CPR, JAMS. Find that, start with it. Add a reference to patent procedures. If you're in a patent case, decide where the arbitration is going to be and decide whether they have a single arbitrator or panel. And you'll get a pretty simple arbitration clause that will do the job, because the real work is done by the AAA rules or the JAMS or the CPR rules. And for years, if you use the sort of magic language you are given, all aspects of the dispute tend to get into the arbitration, which is what you want. The worst thing is if you end up in court to have to litigate about your arbitration, you've really lost all advantage of arbitration, or one of it. So you're better off, it seems to me, with something that's relatively simple. Don't try and write the tax code. Just make sure things get into arbitration. There are some other things, though, that you can consider. But go ahead.
No, I agree with you wholeheartedly in terms of the minimalist approach that you advocate. I think the real work in terms of designing the process should go on at the preliminary hearing, which I guess hopefully we'll have time to talk about that, because that can tailor the hearings to the nature of the dispute. When you're drafting the arbitration clause, it's often very hard to predict what kind of a dispute is going to end up in arbitration. And so I think you avoid the problems that we've mentioned by having a standard arbitration clause. Another advantage of applying an administered body's arbitration rules is that those rules typically provide that the arbitrator can determine the arbitrator's jurisdiction. And that way you avoid the problem of parties running off to court and arguing about whether a particular claim is included within the scope of the arbitration clause or not.
Okay, there are other things you can look at. Some people limit discovery. Whether or not that's a good idea, I don't know. Again, some people assure discovery. And I would say if I were drafting a clause and I wanted to make sure I got at least a deposition or two, I think I would put it in the clause. I'm not sure that's a great idea, but if you do think that's necessary, because, and we can ask the group about this at some point, but some arbitrators allow deposition, some basically don't. And most people, most litigators seem to like at least a few depositions. Whether that's always a good idea, again, I don't know, but it's something that I think you're better off talking out during the preliminary hearing. But if someone's bound and determined to have them, the clause might help. There are other things you can do in the clause. You can set arbitrator qualifications. You can set timing, as Jarkko said. And there are a lot of good ideas for people who want to micromanage things a little more in the AAA clause builder, which you can find online. Okay, one other thing I'd like to, go ahead.
Before we get to the statute of limitations, Mary Ann did have a question about including what type of award you're going to have pursuant to your arbitration agreement. And to me, that's an important decision, particularly in a patent context, because the default, if you read the rules carefully, under the AAA rules, for example, Rule 46B, it says the arbitrator need not render a reasoned award unless the parties request such an award in writing prior to the appointment of the arbitrator, or unless the arbitrator determines that a reasoned award is appropriate. And so it continues to be the default under the rules that it's a standard award, which could be a one-liner, and you certainly don't want that if you have a patent dispute. And so I find that most arbitrators will be inclined to issue what's called a reasoned award, or to ask the parties to agree to that at the preliminary hearing. But even a reasoned award may not get you what you need in a patent dispute. There's a colleague of mine, John MacArthur, that I've served on a couple of panels with, who is about to publish a book on just the law of reasoned awards. And what I've learned in reading some of those drafted chapters is that even a reasoned award provided for in a contract doesn't necessarily produce what is considered to be an enforceable reasoned award. I think that so-called reasoned awards really pass muster with a very low standard, and you'd be surprised to find out what types of, quote, reasoned awards have been upheld by courts who are, more inclined to affirm arbitration awards than to vacate them. So I would recommend, if you have a thorny technical issue or an agreement that implicates patents possibly, to ask for, in your arbitration agreement, for the arbitrators to issue a findings of fact and conclusions of law decision, which I think is probably what you would like in most patent cases.
A little on, I have another thought on that that could be a little more abbreviated, which hopefully we'll get to and go over it. But I think it's true, though, don't you, Yarko, that most arbitrators, if asked, will do a reasoned award. At least that's always been my experience. But I guess you can't count on it under the rules. So.
Yeah, I think I agree with you. That's certainly the way I approach it. But I have heard of situations where parties are very surprised to get a standard award at the end of the process.
Mm-hmm. Yeah, and I'm again, in most arbitrations I've been involved in, that's something we discuss with the parties at in some detail. But I could imagine someone being pretty disappointed if they get just a standard award. Let me talk just a little about statutes of limitations in the context of arbitration clauses. There are cases, one of them from Minnesota, where I'm from, that essentially say state limitations periods don't apply in arbitration because arbitration is not an action. So at least some of the claims in the arbitration would not be subject to statute of limitations defense unless you put something in the clause that says that they are. Now, I haven't studied this right down to the federal patent act, which is 6 years, but it seems to me that that's something everyone would want to consider when they look at their arbitration clause because of this loophole. Some states have different language, and then they find that the state statute does apply, but it's something that could really bite someone. And I had an arbitration where that became an issue. Let's talk about a little bit. Yeah, go ahead.
Just a quick comment. What I've seen is arbitrators will, faced with that argument, will simply find that laches precludes the claim, even though formal statute of limitation doesn't apply.
It's Philip here. Another argument is that the arbitration is effectively enforcing the contract, and so you apply the limitation period to the contract enforcement in terms of making them effectively forcing a party to arbitration. You can't if the time within which to enforce the contract has expired.
Mm-hmm. Yeah, and there are certainly there are arguments like that that can be made. The point I'm trying to make in the slide is if you're in a jurisdiction where that could even be a question, that's something that probably makes a lot of sense to put in the clause. But I appreciate that there are ways to handle that. Okay, let's look at some arbitration issues, administered versus not administered. The people who I know who aren't arbitrators and at least don't arbitrate a lot are immediately attracted to the notion of an ad hoc arbitration where you don't have to pay any administration fees, you don't have to pay the arbitrator. And particularly, I think, in choosing between paying a $200-300 filing fee in federal court as opposed to a significant filing fee at an arbitration organization, some people like to have non-administered arbitrations. So let me throw this one out. Is there any place for non-administered arbitration, situations where that makes a lot of sense? And as part of that, I'm curious from the group whether arbitrators typically recommend administration. If someone comes to you with an ad hoc arbitration, do you say, well, that's okay, that's nice, but actually these things tend to work better if you have an administrator. Here's my idea for that for you. Any thoughts on that, folks?
It's Philip Archie again. Look, again, my experience is a little bit niche, I guess, but when you have international arbitrations of the kind I do, often you'll find the two sets of attorneys will kind of almost jointly administer because they're looking for the specialist arbitrator, and no single administrative body will straddle all the jurisdictions to everyone's satisfaction. So you tend to have technically not administered, but in de facto administered by the attorneys.
Mm-hmm. Okay. Jarkko, if someone comes to you and maybe has AAA rules in there, but under the rules of the AAA, but not the administration, what do you typically do with that situation?
Well, I mean, if their agreement includes, just refers to the arbitration proceeding under the American arbitration rules, by default, they automatically buy into AAA administration. And so I'm not willing to, having spent many years arbitrating for the association, I'm not willing to basically do an end run around their administration by having an ad hoc proceeding. Personally, I prefer a proceeding under the AAA or CPR or JAMS administration, whatever the administering body is, because it avoids a lot of pitfalls. The rules are helpful. I'm able to determine my own jurisdiction. And if I'm handling a case ad hoc, sometimes that happens, I will charge a somewhat higher rate to cover my administrative time managing the case, dealing with payment and that sort of thing, which I prefer not to be involved with. Also, one point that escapes folks is that under the arbitration rules, you can submit a statutory settlement offer like a CCP 998 or the federal equivalent of a statutory offer of settlement, and that gets lodged either before or during the course of the arbitration, and it's not supposed to be disclosed to the arbitrator until after the arbitrator has made an award on the merits, so that they can apply that offer to see whether or not there's any exposure for costs. And that's really not possible in an ad hoc proceeding. At least I haven't figured out a way to allow that to work.
Hello, can I be here? This isn't Michael Diamond. I don't know if I'm coming through. Am I?
Yep.
Well, one point that I've learned in arbitration I just did is this, which was an unadministered panel, and I was complaining about it, frankly, to CPR because it's under CPR, non-administered rules. And I learned both CPR and then talking to Michelle Skipper at AAA that both CPR and AAA ICDR offer a service where they will handle the accounting for an accounting fee. In other words, they'll handle the money, even though they aren't administering it with regard to things like conflicts or disputes or any of those issues. They're not administering anything. They're not reviewing the award, but for a nominal fee, and it is nominal. It's a few $100 an hour. It comes to a few $1,000s, and this was a pretty complex arbitration, went on for quite a while. They will accept the money, keep it, escrow the money, and then pay bills as authorized. And that avoids any of the arbitrators having to handle the money and creating separate accounts and IOLTA or otherwise, and it I think is a great service that can be brought to the attention of the parties even after it starts. Been the case we had. They didn't want to pay the arbitrator. Even though it was a multi-million-dollar thing, they didn't want to pay for administration, but they were perfectly happy to split the costs of having CPR handle the funds.
Is that part of those the new ad hoc procedures?
I frankly didn't see it in the rules of either one, but both CPR, Helena told me, is that Michelle Skipper. So.
Oh, okay. Interesting.
If I could jump in, this is David Kreider in New Zealand. I practice internationally in Asia, and in relation to the point that was just made, both in Hong Kong, the Hong Kong International Arbitration Center, HKIAC, and in Singapore, the Singapore International Arbitration Center, have similar administrative offerings where in an ad hoc case, and I've used these procedures a number of times, the institutions will, as the gentleman just explained in relation to ADR, they will handle the money, or they will provide as much administrative support to the ad hoc arbitration as the parties or the tribunal feel they need at a very reasonable cost. And these procedures have been in effect for a number of years, and I've heard good feedback from many quarters about those procedures.
Thank you. Yeah, that's useful. As usual, I bit off way more than we can chew, so we're getting towards the end of our time. In fact, we're probably past it a little, but I did want to get to the scheduling conference, and if anyone has another obligation, we certainly will not be offended if you go to it, but I wanted to give Jarkko a chance to discuss with me some of the issues about the scheduling conference and some thoughts on that, and then it'll be about time to conclude. And if I don't get to all of your questions or comments, I apologize, but as I said, I think I bit off more than I could chew, even though it's only kind of half of the loaf here, but please go ahead.
Yeah, very quickly, as I mentioned earlier, I think that critical juncture in the arbitration process is the preliminary hearing or pre-hearing conference, and that's where you set the schedule, but you also tailor your arbitration process to the needs of the case. And what I found to be pretty useful is I circulate a template, my standard scheduling order, that includes all of the deadlines that you would typically expect in an arbitration. And I tell the parties that I'd like the lawyers to meet and confer and to discuss it before the pre-hearing conference, and if possible, agree on some of the deadlines and maybe indicate in advance what date they're targeting for their arbitration hearing, how many days they think would be included. And that really helps make the conference go much more smoothly and efficiently. If you want to flush out any threshold or jurisdictional issues at that point, what I provide in my standard template is for the parties to engage in a FRCP Rule 26 initial disclosure by analogy, where you put forward, identify the witnesses that you're going to use, and documents that you intend to rely on. And you can actually tailor that in a patent case to include, if necessary, a claim chart at that stage. Also discuss whether or not you want to have the equivalent of a Markman hearing to consider validity issues, or disclosure, for example, of prior art right out at the outset. That can save a lot of time discovery-wise going forward. And most critically,
go ahead.
No, one more point. Most critically, in my view, is getting the parties to agree on an ESI protocol from the very beginning, identifying search terms, custodians, the format of production, and who pays for what. That's essential, because you can really get off, people get very anxious about discovery even before the preliminary hearing, and they can be producing documents and not be on the same page in terms of how that is to be handled. Dave?
Yeah, I just wanted to mention that particularly in terms of patent litigation, or patent arbitration, excuse me, to make it a little less like litigation. There's a lot that you can do to make things quite efficient. And I note the AAA has some pretty good rules of things to consider, but unlike typical order you see from the Northern District of California or the Eastern District of Texas, you don't have to do it all. So let me give you just a couple examples and things to think about. I had a case where the parties really were in agreement that claim construction was the whole deal. It was a license matter. It wasn't a huge matter, but it was enough that they had it decided, know what they needed to do going forward. So we agreed there'd be an early Markman hearing, that is a claim construction hearing, where the arbitrator, me, would construe the claims, and everything we did was limited to that. So all the discovery and everything was limited to that, made a decision, and that solved the case. So all the other things and costs that often go into these things just didn't need to happen. On the other hand, there have been cases where you need to do just about everything you would in a patent case, right from claim construction through looking at all the prior art and validity challenges and all that sort of thing. And if you need to do that, you can do it. But it makes a lot of sense to see if you can find some threshold things to do first so that you can get the matter resolved, get the parties back to business, knowing what they need to do next without having all the expense of experts, discovery, and all that sort of thing in the right case. Some cases are good for that, some cases are not. And that's really one of the beauties of arbitration, particularly in a patent circumstances, you're able to do those things. Well, I think we've run out of time, and I apologize for that, we had more to say, and I'm sure you did too. But I did appreciate all the comments. I appreciate your interest in this topic. And I can't help but pitch my book, which goes into these and a number of other topics. And if anyone has anything they'd ever like to discuss with me about it, or send me an email or just call me up to go over things, I'd be delighted to do that. One of my favorite topics. I do want to thank Jarkko for your participation today. If anybody wants the slides from the presentation, if you send me an email, I'll send them your way. So you have those notes, and you will have the things that we didn't quite get to. Any final thoughts, Jarkko?
No, I just wanted to thank you and the audience for the opportunity to participate in this webinar.
All right. Well, thank you, and thanks everyone for coming, and we will sign out. Bye now.
Thank you so much. Bye-bye.